Ready for the dictation? Only practice. Ready? Start. Per contra. Learned counsel for the contesting respondents oblique employer has vehemently opposed the arguments of the learned counsel for the petitioner. He would submit that the Central Administrative Tribunal did not pass the order of reinstatement. He never asked for discharging the duties. The case laws relied upon by the petitioner's counsel are distinguishable on facts, hence, it would not apply. He would further argue that there is nothing on record to prima facie believe that the petitioner ever attempted to join the service and he was out of employment throughout the period from his termination till the impugned order is passed. To bolster his arguments, he relied on the case of State of Haryana and others versus O.P. Gupta. In the facts and circumstances of the case and the ratio laid down by the Honorable Supreme Court in the Dipali Gundu Survase, he supported the impugned judgment and order of the Central Administrative Tribunal. Paragraph. The case of Dipali Survase is a landmark judgment on the application of doctrine of no work, no pay. In this case, many other case laws have been considered in the said case on the point of application of the said doctrine. Finally, the Honorable Supreme Court laid down the law under which circumstances the doctrine of no work, no pay would apply. Para 33 is relevant for ready reference. The said paragraph is reproduced, which reads thus: paragraph. The propositions which can be culled out from the aforementioned judgments are: paragraph. First, in cases of wrongful termination of service, reinstatement with continuity of service and back wages is the normal rule. Paragraph. Second, the aforesaid rule is subject to the rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee oblique workman, the nature of misconduct, if any, found proved against the employee oblique workman, the financial condition of the employer, and similar other factors. Paragraph. Ordinarily, an employee or workman whose services are terminated and who is desirous of getting back wages is required to either plead or at least make a statement before the adjudicating authority or the court of first instance that he/she was not gainfully employed or was employed on lesser wages. If the employer wants to avoid payment of full back wages, then it has to plead and also lead cogent evidence to prove that the employee/workman was gainfully employed and was getting wages equal to the wages he/she was drawing prior to the termination of service. This is so because it is settled law that the burden of proof of the existence of a particular fact lies on the person who makes a positive averment about its existence. It is always easier to prove a positive fact than to prove a negative fact. Therefore, once the employee shows that he was not employed, the onus lies on the employer to specifically plead and prove that the employee was gainfully employed and was getting the same or substantially similar emoluments. Paragraph. The cases in which the labor court/industrial tribunal exercises power under section 11A of the Industrial Disputes Act 1947 and the finds that even though the inquiry held against the employee/workman is consistent with the rules of natural justice and or certified standing orders, if any, but holds that the punishment was disproportionate to the misconduct found proved. Paragraph. Then it will have the discretion not to award full back wages. However, if the labor court/industrial tribunal finds that the employee/workman is not at all guilty of any misconduct, or that the employer had foisted a false charge, then there will be ample justification for award of full back wages. Paragraph. The cases in which the competent court or tribunal finds that the employer has acted in gross violation of the statutory provisions and/or the principles of natural justice, or is guilty of victimizing the employee/workman, then the concerned court or tribunal will be fully justified in directing payment of full back wages. In such cases, the superior courts should not exercise power under Article 226 or 136 of the Constitution and interfere with the award passed by the labor court, etc., merely because there is a possibility of forming a different opinion on the entitlement of the employee/workman to get full back wages, or the employer's obligation to pay the same. The courts must always be kept in view that in the cases of wrongful oblique illegal termination of service, the wrongdoer is the employer and sufferer is the employee oblique workman, and there is no justification to give premium to the employer of his wrongdoings by relieving him of the burden to pay to the employee oblique workman his dues in the form of full back wages. Paragraph 6th. In a number of cases, the superior courts have interfered with the award of the primary adjudicatory authority on the premise that finalization of litigation has taken long time, ignoring that in majority of cases the parties are not responsible for such delays. Lack of infrastructure and manpower is the principal cause for delay in the disposal of cases. For this, the litigants cannot be blamed or penalized. It would amount to grave injustice to an employee or workman if he is denied back wages simply because there is long lapse of time between the termination of his service and finality given to the order of reinstatement. The courts should bear in mind that in most of these cases the employer is in an advantageous position vis-a-vis the employee or workman. He can avail the services of best legal brain for prolonging the agony of the sufferer, that is the employee or workman, who can ill afford the luxury of spending money on a lawyer with certain amount of fame. Therefore, in such cases, it would be prudent to adopt the course suggested in Hindustan Tin Works Private Limited. Employees of Hindustan Tin Works Private Limited. Paragraph 7. The observation made in JK Synthetics Limited versus KP Agrawal that on reinstatement the employee oblique workman cannot claim continuity of services as of right is contrary to the ratio of the judgments of 3-judge benches referred to herein above and cannot be treated as good law. This part of the judgment is also against the very concept of reinstatement of an employee oblique workman. Paragraph. In the case of O.P. Gupta, the dispute was about not granting the timely promotions. By the court's order, the seniority list was prepared and finally 90 employees were promoted and given the scale to which they were eligible in the promoted posts. The respondents oblique employee were claiming the payment of arrears. The High Court directed the payment of arrears from the deemed date given in the seniority list to the date of their posting in the promotional posts. Under these premises, it has been observed that unless the seniority list is prepared and finalized and promotions are made in accordance with the rules on the basis of seniority list, the question of entitlement to work in the promotional posts does not